I am back in Virginia, the land of the free, due to several injunctions, one involving me. But if the government had their way, it would be different. But today we're going to be talking about a case out of Louisiana, and it was filed by the Firearms Policy Coalition, and it deals with the age discrimination issue in Louisiana of people that want to carry a firearm. But before we get into that, I want to tell you about something really, really cool, Rich.
What is that, Crump?
I have partnered with We the Free. Do you know anything about We the Free?
I may.
We the Free is where you can find me at without all the YouTube ads, because I'm over there as well, breaking daily gun news, even though I haven't broken a daily gun news in a couple of days because I've been traveling or tired or whatnot. But We the Free offers the latest gun news that's coming down, and some of your favorite creators are there, such as Print Shoot Repeat, who has his own show. Now with We the Free, you're going to get several different things. You're going to get training videos, and you're going to get Netflix quality programming from people like Print Shoot Repeat. If you haven't watched the Print Shoot Repeat show over there, you really should, because it's really, really entertaining. I've been watching it pretty frequently. So go ahead and check it out. There is a link in the description right now, and after the video, there will be a pinned comment with the link. And if you do that, it really shows them, if you click that link and do whatever, it shows them that you guys are getting value out of my content, and I will stay over there, and they will continue to sponsor the channel, which means more videos for you guys. So go ahead and do that. So let's go ahead and get into this case, and we will do that right after I roll the stinger. The case involves Eller Poole, Christian McDuffie, and the Firearms Policy Coalition. And this trio is suing Colonel Robert P. Hodges in his official capacity as Superintendent of the Louisiana State Police. And we're going to get into what the complaint says, because basically it's challenging Louisiana's standing that you can only get a concealed carry permit if you are 21 and over. And it is in federal court for the Western District of Louisiana. Now, this is interesting because it falls under the Fifth Circuit, which is a pretty good circuit for gun rates. So we're going to go ahead. I'm going to share it, and Rich is going to read. And if I still feel like I'm on a freaking boat for some reason.
Aha.
Give me 1 second here. We'll go ahead and bring it up. I'm going to blow it up as well. Not like a Al-Qaeda or ISIS member or some Islamic jihadist. I'm just going to blow it up, like make it easier to read.
It's got to be large print for me.
Exactly. Rich is old. Okay, so this is the complaint for declaratory, injunctive, and other relief. And this is the complaint. They also filed a motion for summary judgment on the same day, which is today.
That's baller.
So let's go ahead and read the introduction. Rich, I'm kicking it over to you.
Sure. The Second and 14th Amendment protected individuals' right to carry a handgun for self-defense outside of the home. New York State Pistol and Rifle Association versus Bruin. The right presumptively belongs to all Americans, not an unspecified subset, and that's Heller versus DC, and also Reese versus the BATFE. On their 18th birthday, the plaintiffs became legal adults for almost all purposes, and certainly for the purpose of exercising their other constitutionally protected rights. They can vote, they can enter contracts, they can get married, they can join the military to fight and die for their country. And as adults, there are no parents or other legal guardians generally responsible for their care and protection. Yet Louisiana laws challenge here. Can you scroll up?
Yeah, just don't read past this, though.
Okay. Here, prevent them from exercising their Second Amendment protected rights on par with all other legal adult Americans. Amen.
Let's go ahead and define what an adult is in reference to the term "the people" in the Second Amendment. New York, not New York. Somebody said New York, and that the courts have long considered the people members of the political class. They're that of the people that reach the age of the majority in the United States. The majority is when you can enter into contracts, get married, do basically everything. Think about it this way: the age that you can vote is the age of the majority in the country, and that is 18. So 18-year-olds are a member of the people in the eyes of the court. So just keep that in mind. We'll get into that a little bit more, but I think it's important for me to bring that up right now.
Yep.
So go ahead.
In 2024, Louisiana enacted Senate Bill number 1, SB 1, which ostensibly allows every person in Louisiana to lawfully carry a concealed weapon in public without obtaining a permit from the state authorities. SB 1.
Okay. Basically also known as constitutional carry. Even though I like permitless carry, because constitutional carry would mean they're not going to do anything. They're not going to do what the Louisiana did and put like an age limit on it or anything like that. It would be just constitutional. That's why I prefer permitless carry, but
right,
it's colloquially known as constitutional carry.
Yes. Okay. So
SB1.
SB1, however, does not deliver on its broad promise given the state's pre-existing regulatory framework for concealed carry, specifically 18 to 20-year-old adults, such as plaintiffs Ella Poole and Christian McDuffie, need a concealed handgun permit to qualify for an exemption from the general prohibition on carrying a firearm within 1,000 feet of a school imposed through Louisiana's firearm-free zone law and federal gun-free zones. Let's see, Louisiana resident aged 21 and over qualify for these permits, but Louisiana's permitting regime still prohibits to forbid Louisiana 18 to 20-year-olds from obtaining such licensure, thereby denying plaintiffs their general right to
carry.
Yeah, I can't read that well because it's behind the text. And it says in Louisiana and cites Berwyn.
Now stop there. Just stop there. Just stop after every.
Okay.
Thing. All right. Because remember when I said I don't like calling constitutional carry because there's restrictions on it?
Yes.
A good example is Louisiana's firearms free zone law and the gun free zone act. That's why I refer to it as permitless carry.
Okay. There's another interesting tidbit about Louisiana is if you're 18, you can open carry.
Yeah, you can open carry at 18, but you can't attain a license
to
concealed carry, which is absolutely ridiculous. Which is stupid.
The Fifth Circuit has confirmed that 18 to 20-year-olds were indeed part of the people for the Second Amendment purposes, and it cites Reese, and there is no historical tradition that justifies treating such adults on discriminatory footing compared with adults over 21 years of age. And see Worth v. Jacobson, and that's holding that Minnesota's 21-year-old age limit for carry licenses violates the Second Amendment, and that's Lara v. Comer.
Lara v. It's Commissioner of State Police.
Oh, Commissioner. Okay, I was trying to figure out.
It's Laura. It's Laura.
Laura. Okay.
That was a decision out of the Third Circuit Court of Appeals, which is surprisingly made up of liberals, but they have ruled for Second Amendment rights recently.
Oh.
Even though that the person that just wrote the historic assault weapons ban case in Cheeseman versus Placken is a Biden appointee, but some like I said, not all judges that are liberals are activists on the Constitution, and the head of the Third Circuit seems to be that. Now, okay, so in Laura, they ruled against the Pennsylvania State Police, right? They said that denying someone under 21 for the right to carry, it violates the Second Amendment. Pennsylvania appealed it to the Supreme Court. What they filed for, it's called a writ of certiorari. You petition the Supreme Court to hear your case. The Supreme Court doesn't have to hear your case. And in this, the Supreme Court denied cert recently in 2026. June 2026, so less than a couple weeks ago. So that means, since they denied cert, that the court's decision striking down Pennsylvania's law stands.
Wow.
And that it ends that debate on that law, because there's nowhere else they can go. Kinda. I mean, Pennsylvania could file for what's called a motion to reconsider, but the Supreme Court is not going to do anything with that. So, for all intents and purposes, that's settled case law in the Third Circuit, at least.
Wow.
But they can use that, even though this is the Fifth Circuit, they can use that as the Fifth Circuit isn't bound by what the Third Circuit says. But what they can do is they can file what's called a motion of supplemental authority. And that says, hey, look at what this other circuit court said. They're not bound by it, but they can be weighted by it.
Gotcha.
If that makes any sense.
Yeah. Louisiana's regulatory scheme prohibiting 18 to 20-year-old adults from obtaining concealed handgun permits violates the Second and 14th Amendment. The court should enter judgment that declares Louisiana's age requirement unconstitutional and joins defendant and all those under defendant's supervision from enforcing it in jurisdiction and venue.
Stop right there. So okay. So let's go ahead and talk about how the Second and 14th Amendment applies here. We're going to skip jurisdiction and venue and plaintiff and everything, because that doesn't matter. We're going to go down to general allegations. But okay, the Second Amendment, right to keep and bear arms shall not be infringed. We all know that. The right of the people to keep and bear arms should not be infringed. We're going to get into who the people are and what the terms bear arms is according to Supreme Court decisions, particularly in Heller, Bruin, and Wolford. We're going to reference all of that when we break it down of who the people are and what the right questions are, because a lot of times they dodge it, but they can't do that anymore due to Wolford. We're going to talk about that as well. The 14th Amendment. The 14th Amendment basically, it doesn't change anything. It just affirms that the Bill of Rights, which includes the Second Amendment, applies to the states as well. So that's saying that the states cannot violate like the Bill of Rights or any constitutional amendment, really, because it applies to the states. Before the 14th Amendment, there were people that would argue, and this is back in 1868, that the states are exempt from the U.S. Constitution, so they can establish religion, they can, restrict speech, they can, do all this other stuff that the federal government was forbidden to do. The 14th Amendment clarifies that and affirms that the state cannot do that. So that's why it is a violation of the Second and 14th Amendment. The Second Amendment lays down the rights. The 14th Amendment affirms that those rights, or as I like to call the Bill of Rights, the documented negative liberties, because it restricts what the federal government can do. It says that the states are also restricted on doing these. So let's go ahead and do the general allegation.
In 2024, Louisiana enacted SB 1, which broadly authorizes individuals over the age of 18 to carry a concealed handgun in public without a permit throughout the state. SB 1 took effective July 4th, 2024. SB 1's general protections extend to plaintiffs Poole and McDuffie. Despite SB 1's embrace of general right to carry absent a license, Louisiana still allows individuals to apply for a concealed handgun permit issued by the state of Louisiana. See blah. Louisiana requires, however, that to qualify for the concealed handgun permit, an applicant must be 21 years of age or older.
So basically, what you were saying earlier, which we're going to get to down here, if you're 18 or between 18 and 20, you can open carry, but you cannot receive a handgun permit.
Right.
And we're going to, in number 15 is going to get into why that is a problem.
Closing off the ability to obtain a concealed handgun permit has a real practical effect on the constitutionally protected right to carry a firearm in public for self-defense. Louisiana law bars the carrying of concealed handguns in any zone or area in which firearms are banned by state or federal law. Federal law bans possession of firearms within 1,000 feet of school grounds unless, among other exceptions, the individual possesses concealed carry license from the state in which the school is located.
Now, that's where we get into the big crux of the issue here, is that there is often an argument that can be made for the equal protection clause as well, because you're giving more rights to those like over 21 than under 21.
You're denying a class of people and granting it to another class of people.
Yeah, which violates the equal protection clause of the 14th Amendment as well. So I just wanted to bring that up, but I wanted to wait to bring that up until we got to this part.
Louisiana has its own 1,000-foot radius rule, but generally excludes both permit holders and persons 18 years of age or older, not prohibited from possessing a firearm under state or federal prohibited persons laws, who carry a concealed handgun. The net result is that Louisiana's exclusion of 18 to 20-year-olds from eligibility for a concealed handgun permit effectively bars them from carrying within 1,000 feet of a school under both state and federal law. These 1,000-foot gun-free zones emanate from each and every school in the state, making it impossible for those without carry permits to lawfully carry a firearm in the state through and from any number of destinations. This prohibition includes merely passing through one of these zones. Based on publicly available data, there are more than 1,300 elementary and secondary schools in the state. Importantly, these 1,000-foot gun-free zones are not marked or identified in any particular way and encompass vast swaths of public and private property.
All right, just finish this off, then we'll stop. I wanted to bring up points here.
Including major and minor roads and thoroughfares throughout the state, these zones in and of themselves are not and cannot be so-called sensitive places. New York State Pistol and Rifle Association versus Bruin. Thank you, Judge Clarence Thomas. Cautioning against expanding the category of sensitive places such that it would eviscerate the general right to publicly carry arms for self-defense.
Yeah, okay, so here's the thing, right? There's a lot of schools everywhere, and you're within 1,000 feet of a school. No, like pretty much like 60, maybe 80% of wherever you are. So if
that could be an interstate highway.
That could be an interstate highway, correct. So you can be driving, not aware that you're breaking these unconstitutional laws, and you could be breaking these unconstitutional laws just by driving. You don't even have to know that there's a school there. And in fact, there's no school markings that says there's a school within 1,000 feet there. Now let's get to another point. Let's say you live across the street from a school.
Your house is a gun-free zone?
And your house is basically you are not allowed to carry a gun in your private property because there's no exemption for private properties in either of these laws. So that is a huge issue here.
Wow.
All right, keep on going.
Although the law exempts the possessions of a firearm on private property not part of school grounds, as well as an unloaded firearm stored in a locked container in a motor vehicle, the extensive coverage of its 1,000-foot school radius prohibitions impose a significant burden on plaintiffs' ability to exercise their Second Amendment protected right to publicly carry a firearm. Furthermore, 18 to 20-year-old adults like plaintiffs are also deprived of other legal benefits that are granted to carry license holders. Under Louisiana law, carry license holders are immune from damages caused by a justified use of force or self-defense.
We didn't stop.
Sorry.
I thought there was no exemption, but I guess their private property is exempt from it.
Okay.
So my bad. Oops, I read through this too fast, I guess, earlier on.
So, yeah, it gets you some additional benefits. Let's see. The handgun, individuals 18 to 20-year-olds carrying a handgun pursuant to the general right to constitutional carry do not get the benefit of such immunity.
That is correct. And that's the main problem with this lawsuit, which is why we get an equal protection clause.
Plaintiffs are law-abiding responsible citizens who wish to exercise their Second Amendment protected right to bear arms in public for self-defense on par with all other Louisiana adults obtaining a concealed handgun permit. The state's regulatory scheme, however, deprives plaintiffs of any path to do so.
Okay, now so that's basically it for that. Let's go ahead and read through this, then we're going to break down some of my thoughts here.
Plaintiffs incorporate here by reference paragraphs 1 through 20 supra as if fully set forth herein. Louisiana's regulatory scheme prohibiting 18 to 20-year-old adults from obtaining concealed handgun permits violates the Second and 14th Amendment. The Second Amendment is applicable to the states through the 14th Amendment, McDonald City of Chicago, incorporating through substantive due process. Let's see, Thomas concurring, incorporated through privileges or immunities clause. To determine whether a firearm regulation is constitutional under Bruin, the analysis begins with whether the Second Amendment's plain text covers an individual's conduct. If so, the Constitution presumptively protects that conduct.
Okay, let's go ahead and talk about this because this is the first step, the plain text. And for a lot of other laws after Bruin was decided, a lot of the liberal activist judges have said, well, this arm is not covered under the plain text of the Second Amendment. In Wolford, they pushed back on that because they said the only two questions you ask at step one of a Bruin analysis is the person a member of the people, which these guys definitely are a member of the people. They're the age of the majority of the United States, 18. And is the arm bearable? Now, if you want to say the arm is bearable, but it's not covered under the Second Amendment, you have to do that in step two. So is the arm bearable? Handguns undoubtedly are bearable arms. Therefore, the arm is protected by the Second Amendment, and the conduct of the person carrying the arm is protected by the Second Amendment. And after that, that's all the Firearms Policy Coalition here has to prove in step one of Bruin. Now, after step one of Bruin, it shifts to step two of Bruin, where the burden of proof falls on the state, where they have to prove that a law is consistent with a historical tradition of firearms regulations in the United States from the founding era. And I know a lot of people will argue that, 1868 is the founding era because of the 14th Amendment, but we also have something in Hermione that says you cannot use racist gun laws anymore that were black codes from the Reconstruction era to justify your racist gun laws. So basically, the black codes that they would reference, they kind of can't anymore. And I believe that the founding era is 1792, the ratification date of the Second Amendment, because the 14th Amendment didn't change anything about the Second Amendment. It just affirmed, and didn't change it to make it affirm. It affirmed that
Right.
the Second Amendment applies to the states as well. So,
Are you saying the Democrats can't Democrat anymore?
I mean, the judge in the Third Circuit is a Democrat, and she wrote the decision. The Biden appointed judge at that. All right, so I moved it up to where we were.
So if the Constitution presumptively protects that conduct, if that requirement is satisfied, the government must then justify if its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. In other words, it is Louisiana's burden to affirmatively prove that its firearms regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms.
And they're going to have a huge issue doing that. No. And that's where they were for Wolford, where I just referenced, right?
Yep. Bruin and Wolford have already established that the Second Amendment covers the plaintiff's proposed conduct here, carrying arms publicly for self-defense and other lawful purposes.
Stop right there. Stop right there. Because before you would always say, oh, this gun is not used for, is not in common use for self-defense. Wolford changed it and says in use for offensive or defensive purposes. So offensive purposes, defensive purposes. So that removes the self-defense.
Yes.
Offensive purposes can be anything. Target shooting. It can be hunting. It can be...
Doesn't have to be sporting purposes.
It doesn't have to be sporting purposes at all. It could be clearing your house. It could be, defending yourself against the tyrannical government. It could be any of those reasons.
Okay.
Any legal reason, any lawful reason. Now, you can't say, well, I want to use this to go rob a bank, because that would not be a lawful reason. But the majority of firearms are not used for that purpose.
Correct. Therefore, the Second Amendment presumptively protects the plaintiff's right to carry firearms in public in Louisiana. And citing Bruin and Reese, stated another way, Louisiana's regime is presumptively unconstitutional, citing Wolford.
Yep.
Under Bruin, the burden now shifts to Louisiana. It must show that its age requirement is consistent with the nation's historical tradition of firearm regulation when the government regulates arms-bearing conduct, as when the government regulates other constitutional rights. It bears the burden to justify regulation, United States versus Rahimi, and quoting Bruin, and it must do so by offering persuasive legal history. See Bruin, courts decide a case based on this historical record compiled by the parties. And Himani, did I say that right?
Hamani, but...
Hamani, okay. Louisiana cannot meet this burden. There is no well-established and representative historical tradition of restricting the ability to bear arms for law-abiding, responsible 18 to 20-year-old adults. And let's see. Concluding that restricting the Second Amendment rights of 18 to 20-year-old adults was inconsistent with the nation's historical tradition of firearm regulation, and it cites Worth, and same for Lara. Accordingly, prohibiting 18 to 20-year-old adults from obtaining a concealed handgun permit in Louisiana violates the Second Amendment.
Okay, let's go ahead and talk about this really quick here, because this is definitely interesting here. Okay, what their argument is going to be is the age of majority of the founding was 21, which is true. But then you got to look at the firearms regulations, and there was a lot of firearms regulations that required 18-year-olds to own firearms. There's a bunch of different things right there. And what they're also going to say is the courts have held, even though that 21 was the age of the majority at the founding, even though it doesn't apply to firearms at all. You got to look at what the age of the majority is now. And basically, what they want, because a permanent injunction, they want court costs and everything else, and basically, they want to shrink down the law.
Amen.
Yep, that's basically it. Just wanted to make you guys aware of this case going through, and with that, we're gonna get out of here. Okay.
All righty.
Great. Thank you so much, Rich.
Thank you, Crumpy.
For joining me over
Type
at
in.
We the Free. I've been a long time no talk. Join me at Read the Free. The link is in the description. Thank you so much, and talk to you later. Bye bye.